So, good morning to all of you. I hope all of you are doing great. So, let's start today's discussion. Today, we are planning to discuss MP Civil Judge 2019 Phase 1 Shift 2 question paper, in which we are going to discuss question number 81 onwards. If you people remember, so in the last class, in yesterday's class, we have discussed till question number 80. So today we are going to discuss question number 81 onwards. Now, if I am going to talk about question number 81, from question number 81 to 110 we are going to cover today. So question number 81 ये आपका IPC से होगा, then we are going to discuss CRPC, then we are going to discuss some of the questions of Negotiable Instrument Act. Now, अगर अभी तक आप लोगों ने हमारी वीडियोस को देखा है, ऑब्जर्व किया है, एंड इफ यू लाइक द कंटेंट विच इज अवेलेबल ऑन आवर चैनल, so don't forget to subscribe our channel and don't forget to press the bell icon if you find particular video interesting for you. And if you people haven't enrolled for MP Civil Judge Prelims crash course, link is below in the description box. Thus do check it out. इसमें आपको 10 से ज्यादा मॉक्स मिलते हैं, रिकॉर्डेड वीडियो लेक्चर्स मिलते हैं फॉर ऑल द सब्जेक्ट्स, वन ऑन वन मेंटरिंग एंड डाउट क्लियरिंग सेशन मिलता है. तो चलिए आज के डिस्कशन को शुरू करते हैं. क्वेश्चन नंबर 81, राइट टू प्राइवेट डिफेंस इज नॉट अवेलेबल. राइट टू प्राइवेट डिफेंस इज नॉट अवेलेबल. ऑप्शन ए, अगेंस्ट एन इंसेन. ऑप्शन बी, अगेंस्ट चाइल्ड. ऑप्शन सी, when there is sufficient time to take recourse to public authority, and option D, all of these. So right to private defense is not available. Option A, against an insane person. B, against a child. Option C, where there is a sufficient time to recourse a public authority, and D, all of these. So question number 81, what should be the correct answer? Yes, anyone having any idea? So for this particular question, the correct answer will be option number C, which is stating when there is a sufficient time to recourse to public authority. It simply means when the party is having the time to reach to the public authority, then in that case, the party cannot exercise right to private defense. So its correct answer is going to be your option number C, right? I hope it is clear. Now, next question, question number 82. A finds a valuable ring. A finds a valuable ring, not knowing to whom it belongs. A sells it immediately without attempt to discover its owner. A is guilty of offense under section dash 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 of Indian Penal Code. So it is a filling the blank form of question in which what they are asking, that A found a valuable ring, not knowing to whom it belongs. A sells it immediately without attempting to discover its owner. A is guilty of offense under section dash 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 of Indian Penal Code. Your options are option A, section 403, option B, section 379, option C, section 406, and option D, section 384. So what should be the correct answer for this? Now, here you have to understand that its correct answer will be option A, that is section 403. Now, section 403 is talking about dishonest misappropriation of the property. Dulian Lamagauji, 82. Yes, 82 is the correct answer, Dulian ji. But here you people have to remember one important thing. Good morning, Ujjwal Naharji. You people have to remember one important thing. What is that important thing? Now, let me tell you. Suppose, sir, what was the first question? Ujjwal Naharji. Ujjwal ji, you can have a look of this particular question. Right to private defense is not available to. So its particular question's answer was C, Calcutta. That is where there is a sufficient time to recourse to public authority. Right? Now, question number 82. Its correct answer will be 403. That is dishonest misappropriation of property. Now, here you have people have to remember that suppose for a moment, if this particular statement is not there, if this particular statement is not there, that A sells it immediately without an attempt to discover its owner, then its correct answer is automatically going to change to none of the above. Yeah, the person will not be held liable for any offense. So only picking up valuable security lying on road, without knowing to whom it belongs to does not make a person liable to an offense, right? So its correct answer will be A. Next question, question number 83. Nothing is an offense which is done by a child under 7 years of age. Good morning, Ankita ji. Nothing is an offense which is done by a child under 7 years of age is based on the Latin or legal maxim of option A, Doli capax, option B, Doli incapax, option C, D, minimis non curat lex, and option D, none of these. Question number 83. Nothing is an offense which is done by a child under 7 years of age. This principle is inculcated under section 82 of Indian Penal Code, right? So this particular section 82 of Indian Penal Code is based on which Latin maxim? Doli capax, Doli incapax, D minimis non curat lex, and none of these. So what should be the correct answer? Yes. Question number 83. Its correct answer will be B for Bangalore. That is Doli incapax, right? Now, next question. Question number 84. A, knowing that B has murdered Z. A, knowing that B has murdered Z against B to hide the body with the intention of screening B from the punishment. Yes, Viniji 83, B is the correct answer. A, knowing that B has murdered Z against B to hide the body with the intention of screening B from punishment. A is liable under section. Option A, section 302. Option B, section 109. Option C, section 204. And option D, section 201. What should be the correct answer for question number 84? So for question number 84, the correct answer is going to be your yes. A, knowing that B has committed murder against B to hide the body with the intention of screening B from punishment. So 84 ka correct answer will be your option D, that is section 201. Yes, Ankita Gupta ji, question number 83 ka correct answer will be B for Bangalore. 84 correct answer is 201, right? So it is stating when a particular offender try to screen when a particular person try to screen another person from an offense, he is going to be held liable under section 201. Question number 85. No, Viniji, 84 ka correct answer will not be B. Its correct answer will be D for Delhi, right? Now 85. A holds Z down. A holds Z down and fraudulently takes Z money and jewel from Z's cloth. So what first A has done? Firstly, A holds Z down and then fraudulently takes Z's money and jewels from Z's cloth without Z's consent. For doing aforesaid, A voluntarily caused wrongful restraint to Z. A committed option A, theft, option B, robbery, option C, dacoity, and option D, cheating. What should be the correct answer for this question? Question number 85. So its correct answer is going to be robbery, right? Suppose like if you will read the definition of robbery, it is simply stated over the section that a particular person is going to be held liable, like when theft is going to be turned into robbery, when a person uses some sort of force, physical force. So its answer will be B for Bangalore, right? I hope it is clear to all of you. Now, next question is question number 86. A designated B, A instigated B to murder C. Yes, Dulian Lamagao ji, Vinny ji, all of you are correct. Its correct answer will be B for Bangalore. Question number 86. A instigated B to murder C, who refuses to do so. A is guilty of. So here in question number 86, A instigated B to murder C, who refuses to do so. A is guilty of. Yes, Ankita Gupta ji, 85B is the correct answer. Option A, no offense. Option B, abatement to commit murder. Option C, criminal conspiracy. And option D, abatement to culpable homicide not amounting to murder. So here A instigated B to murder C, who refuses to do so. A is guilty for the offense of option A, no offense. Option B, abatement to commit murder. Option C, criminal conspiracy. And option D, Abatement to commit culpable homicide not amounting to murder. So its correct answer will be B for Bangalore. That is abatement to commit murder. Yes, 86B is the correct answer. Avi Singh, oh, Viniji, Dulian Lamagao, all of you are correct. Its correct answer will be B. Question number 87. Right. Question. Yes, Ujjwal Naharji, B is the correct answer. 87. A and B are good friends. Right. A proposes B for marriage, but she denies. A, in suspicion of B's love affair with someone else, monitored her mobile phone and email account used by B. What offense has committed by A? Option A, outrage the modesty. Option B, voyeurism. Option C, stalking. Option D, none of the above. So question number 87, its correct answer for question number 87, correct answer will be your offense of stalking, right? C. Yes, Avi Singh ji, C, stalking is the correct answer. Yes, Dhulian ji, Vinny ji, all of you are correct. Question number 88, an act which is done by a judge when acting judicially in exercise of any power which is or which in good faith he believes to be given to him by law, then the act of judge. Option A is an offense because judge should have knowledge of law. Option B is not punishable. Option C is punishable. Option D is unpardonable and maximum punishment should be awarded. Yes. What should be the answer for question number 88? Question number 88. Yes, Dhulian Lamagao ji, its correct answer will be B. Avi Singh ji, its correct answer will be B, because it is not an offense under section 77 of Indian Penal Code, which is defining the act done judicially are not offense. 88 B is the correct answer. Yes, Vinny ji, all of you are correct. Next question, question number 89. A poor student finds a letter on the road containing a banknote. From the content and direction of the letter, yes, Ujjwal Naharji, 88B is the correct answer. So, a poor student finds a letter on the road containing a banknote. From the content and direction of the letter, he learns whom the note belongs to. A uses that note for buying some books. A has committed option A, the offense of dishonest misappropriation of property. Option B, the offense of theft. Option C, no offense. And option D, the criminal breach of trust. 89 ka correct answer will be dishonest misappropriation of property. Yes, Dulian Lamagao, you are correct. Now, next, let's move further with question number 90. Vinny ji, you are also correct. Maniac Rover ji, you are also correct. Its correct answer will be A. Ujjwal Nahar ji, you are also correct. Now, question number 90. Out of these offenses against property, the right to private defense is not available. Yes, Avi Singh ji, you are also correct. Question number 90. Out of which of these offenses against property, the right to private defense is not available? A, criminal breach of trust. B, criminal trespass. C, robbery. And D, attempt to commit mischief. Question number 90. Out of which of the following offenses against against the property, the right to private defense is not available? So 90 ka correct answer will be, that is criminal breach of trust. Avi Singh ji, 90 ka it will not be B, its correct answer will be A, that is criminal breach of trust. Yaad rakhiye, if you will read like section 101, 102 and 103, you will get a clear idea that in the case of criminal trespass, in the cases of robbery, in the cases of mischief by fire or mischief with intent to cause death of a person, in all these cases, right to private defense can be exercised, right? So its correct answer will be A. No, Dhulian ji, Ujjwal Nahar ji, its answer will not be C or D. Maniac Rover ji, yes, its correct answer will be A, that is criminal breach of trust. So, when the offense of criminal breach of trust is committed when a particular person entrusts another over a property. So here you have to understand that simply if a person has entrusted another over a property and then if he misused that particular property, you cannot use your right to private defense against that particular person. That's how its answer will be A, right? Thank you, sir. We are revising. Okay, very good, Dhulian ji. Now, Question number 91. Under section 313 of CRPC, Criminal Procedure Code, the statement of the accused, option A, is recorded on oath, option B is recorded without oath, option C, either on oath or without oath as per the direction of the court, and option D, the court can exempt from oath. Question number 91. Section 313 of CRPC, the statement of the accused is recorded on oath, option B, without oath, option C, either on oath or without oath, option D, the court can exempt from oath. So question number 91, this is the first question of CRPC. What should be the correct answer? Yes, its correct answer is, Vinny ji, you are correct. Its correct answer will be that the statement has to be recorded without oath. Now remember, if they are mentioning that under section 315 of CRPC, under section 315 of CRPC, the statement of the accused, then there under section 315, the statement of the accused is going to be recorded on oath. Question number 92. Anticipatory bail under section 438 of CRPC 1973 can be invoked in the cases of anticipatory bail. Yes, Ujjwal Nahar ji, its answer will not be A. 91 ka correct answer will be B for Bangalore, right? Now, anticipatory bail under section 438 of Criminal Procedure Code 1973 can be invoked in the cases of option A, bailable offense, option B, non-bailable offense, option C, bailable offense and non-bailable offense both, and option D, none of these. Yes, Vinny ji, its correct answer will be non-bailable offense, right? So 92 ka correct answer will be B for Bangalore. Next question is 93. Under chapter 21 of CRPC, Criminal Procedure Code, what is the maximum sentence of imprisonment which can be imposed for an offense tried as summary trial? So in the cases of summary trial under chapter 21 of CRPC, what can be the maximum punishment imposed by the court? So its correct answer for question number 92, Ujjwal Nahar ji, A will not be the correct answer. Remember that in the case of bailable offense, yes, B is the correct answer. Question number 93, its correct answer will be option C, that is 3 months. So question number 93 is simply stating that in the cases of summary trial, the maximum offense can go to the maximum punishment can go to the particular offense that can be of 3 months, right? Next question, question number 94. Under Criminal Procedure Code, in which provision examination of the accused is made after the prosecution evidence? Under Criminal Procedure Code, in which provision examination of accused is made after the prosecution evidence? Your options are section 311, option B section 313, option C section 315, and option D section 317. So what should be the correct answer for this particular question? Provision regarding examination of the accused is made after the prosecution evidence. Prosecution evidence ke baad the examination of the accused. Yes, its correct answer will be option C, that is section 315. Yes, Janvi ji, you are correct. Vinny ji, it will not be under 313, right? Now they are simply stating examine. Just a second, just a second. Yes, so its correct answer will be C. Now next question, question number 95. Just give me a microsecond, let me just check it, because question number 94, yes, question number 94, its correct answer will not be C. Its correct answer will be option B for Bangalore, right? It was my bad. I apologize for the same, like I was in the rhythm, so I was not able to connect. So under CRPC, in which a provision examination of the accused, now examination of the accused ka provision is given under section 313, and section 315 is stating that the accused person can be a competent witness of defense. So its answer will be B. So yes, Vinny ji, you are correct. Janvi ji, its answer will not be C, its answer will be B for Bangalore. Now next question, question number 95. Now magistrate of first class passes a sentence of fine of ₹100 only, appeal can be made to option A, Sessions Court, option B, High Court, option C, Chief Judicial Magistrate Court, and option D, no appeal can be made. Question number 95. So they are stating that when the judicial magistrate of first class passes any particular sentence of fine, okay, of ₹100. So what should be the particular punishment for that? What should be the provision for appeal for that particular thing? 95. Yes, D is the correct answer, Janvi ji, that no appeal can be made. Now, I hope all of you are aware that in the cases where the magistrate of first class passes the fine of ₹100, or the chief judicial magistrate passes, or like the court of session passes the punishment of particularly 3 months or the fine of ₹200, then no appeal can be made. If the high court passes the punishment for 6 months and the fine of ₹1,000, then no appeal can be made. So its correct answer will be D for Delhi. Now next question. Question number 96. Under section 167 of Criminal Procedure Code, the longest period for which an accused can be remanded to the police custody is, under section 167 of CRPC, the longest period for which an accused person can be remanded to the police custody. So it should be option A, that is 14 days. An accused person can be remanded into the police custody for the maximum period of 15 days, right? So the accused person can be remanded into the police custody for the maximum period of 15 days. So 96 ka A is the correct answer, right? Yes, Viniji, you are correct. Question number 97. Rather than reading this particular question, I am going to request humbly all of you to read this particular question on your screen first, because this question is quite technical, right? So read this particular question very much calmly. Don't create panic while answering this particular question, question number 97. As per the provision of subsection 3 of section 389 of Criminal Procedure Code 1973, the trial court shall release a convicted person on bail who intends to present an appeal. In which of these cases, in the case of these, the trial court can release the convicted person. Option A, the person is convicted for offense under section 435 of IPC, is sentenced for 7 years. Option B, the person is convicted for offense of section 327 of IPC, sentenced for 5 years. Option C, the person is convicted for offense under section 457 of IPC, is punished for 4 years. And option D, none of these. Question number 97. What should be the correct answer? You can take up your required amount of time, because this question requires a lots and lots of patience for answering this particular question. You people have to recall in your mind that what section 389 of CRPC is stating about. Yes. So question number 97. What should be the correct answer for this question? Can anyone tell me question number 97? Yes. Its correct answer will be D for Delhi. Now, as per the official answer key, model answer key of MP High Court, they are stating that its correct answer is A. But I feel its correct answer should be D, none of these. Because if you people are going to read section 389 of CRPC under subsection 3, they are simply stating this statement that no offense punishable with 3 years or more. No, Vinny ji, its answer cannot be C. Like as per MP High Court official answer key, they are saying its answer should be A. But as per me, its correct answer should be D, none of these. Because section, now here I am going to show you that particular provision which I am trying to convey with you all, right? Just give me a second so that I can show you the exact provision, right? Just give me a second. I'm going to show you the provision as well to make this particular doubt clear from your mind. Section 389 of CRPC, right? So they are stating section 389 clause C, right? So you can read third clause what they are stating. Firstly, section 389 is talking about suspension of sentence pending the appeal, release of the appellant on bail. So the third provision is stating when the convicted person satisfies the court by which he is convicted that he intends to present an appeal, the court shall, when such person being on bail is sentenced to the imprisonment for a term not exceeding 3 years, right? Not exceeding 3 years. This is something you people have to understand. Or where the offense is of which such person has been convicted is a bailable one, and he is on bail. Order that the convicted person to be released on bail unless there are special reasons for refusing the bail. Okay? So what should be the correct answer after reading this particular provision? I think after reading section 389 clause 3 subclause 1, its correct answer should be D, none of the above. Okay, as per MP High Court they are stating its correct answer is A, but I will still go with option D. I hope it is clear to all of you. Question number 98. As per section 372 of Criminal Procedure Code 1973, a victim shall have a right to prefer an appeal, but he cannot file against the order which is, okay, as per section 372, like the victim has right to prefer an appeal, but he cannot file appeal against the order of option A, where the court has acquitted the accused, option B, where the court has convicted for a lesser offense, option C, where the court has imposed inadequate sentence, and option D, where the court has imposed inadequate compensation. So what should be the correct answer for question number 98? Question number 98, what should be the correct answer? Can anyone tell me what should be the correct answer for question number 98? Yes. So for question number 98, the correct answer will be when the court has imposed inadequate sentence. In that particular case, yes, C is the correct answer, Viniji. Now, so it is simply stating when the court has imposed inadequate sentence. In that case, no appeal can be preferred. Next question, question number 99. Which section of the Code of Criminal Procedure mandates that no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same except to correct a clerical or arithmetical error? Option A, section 463, option B, section 361, option C, section 362, and option D, section 363. What should be the correct answer? Right, removal of arithmetical or clerical error. So for this particular thing, which provision is correct? What should be the correct answer? So its correct answer will be C for Calcutta, that is section 362, right? Next question, question number 100. A person is convicted for life imprisonment for the offense of section 302 of Indian Penal Code 99. Viniji, D is not the correct answer. Its correct answer will be C, that is under section 362. Section 363 is talking about supply the copy of judgment to the accused, right? So its correct answer will be C. Question number 100. A person is convicted for life imprisonment for the offense of section 302 of IPC. The appropriate government may commute the sentence for the minimum period of option A, 30 years, option B, 20 years, option C, 14 years, and option D, 7 years. 30 years, 20 years, 14 years, and 7 years. What should be the Ujjwal Nahasa? Can you show question number 99 again? Sure, Ujjwal ji, you can have a look of this question. This is the question. Which section of Criminal Procedure Code mandates that no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same except to correct a clerical or arithmetical error, right? Section 463, then 361, 362, and 363. So its correct answer is option C, that is section 362. Now, question number 100. Yes, Viniji, its correct answer will be C, that is 14 years. So when a person is convicted of life imprisonment, the government may commute the sentence of life imprisonment to a minimum imprisonment of 14 years, right? Next question. Question number 101. Besides section 209 of CRPC, Code of Criminal Procedure, which other section also provides for committal of the cases to the Sessions Court? Your options are option A, section 315, option B, section 318, option C, section 323, and option D, section 326. So what should be the correct answer? Besides section 209, its correct answer will be yes. Viniji, you are correct. Its correct answer will be section 323. So section 209 is talking about committal of the case before the conduction of trial, or you can say before the trial has begun. And option C is talking about section 323, which is states that committal of the case to the court of session after the conduction of trial. Question number 102. Yes, Viniji, you are correct. Its answer will be C for Calcutta, right? Now, question number 102. Which irregularity vitiate the proceeding if magistrate not being empowered? Question number 102. I will suggest you all to take up some time with question number 102, because if you people have read section 460 and 461, so it is quite challenging to remember all the provisions of 460 and 461. So take up your time with question number 102 and answer it with a much calm manner. Option A, issue a warrant under section 94 of CRPC. Option B, hold an inquest under section 176 of CRPC. Option C, tries an offender summarily. And option D, tender a pardon under section 306 of CRPC. Now, how many of you are there, those who are facing problem to remember section 460 and 461 ka provision, and they always feel that they are missing 1 or 2 marks by that particular provision, either in mock test or in the final exam? I will tell you a trick through which you can remember it. So if you people are facing problem, just let me know to remember this particular thing, like the proceeding which vitiate the trial and which does not vitiate the trial, right? And let me know the answer of question number 102 as well. Let me know what should be the correct answer with question number 102. Yes. What should be the correct answer? Yes, sir, it's difficult. Okay, Viniji. Now, I am going to tell you an interesting thing to remember these particular provisions, right? How you have to remember is, you don't have to remember both of the provisions. Okay? Remember, either you will get the question which irregularity vitiate the proceeding or which irregularity does not vitiate the proceeding. So 102, its correct answer is C. It's not A, Viniji. Its correct answer will be C. That is, tries an offender summarily. Now, what I was stating, that with question, with this particular thing, you will find the question in your prelims this way. Either the question will be vitiate the trial or does not vitiate the trial. So you can remember the proceeding which does not vitiate the trial. ठीक है, because does not vitiate the trial के जो provisions है वो काफी कम है as compared to the provisions of vitiate the trial. Now, and try to remember those particular provisions in a chronological order. ठीक है. Now let me tell you what you have to do. Firstly, you have to remember that Section 94. Section 94, you have to remember, right? That is talking about search warrant, right? Then after section 94, what you can do, you can remember the upcoming provision in that league, in that chain. Okay. Now, agar aap section 94, I hope like you people want me to explain it through this way, or you people want me to go with the questions. Just let me know quickly. Just let me know quickly. If you people want me to go with the questions, I can go with the questions. Or if you want me to discuss this thing, I can discuss this thing as well. Just let me know. I'm waiting for your reply, all of you. Questions, sir. Perfect. Okay. So, question number 103. Whether before conclusion of the trial and before disposal of the appeal, accused person can be asked to execute bail bonds to appear before a higher court. Whether before conclusion of trial and before disposal of the appeal, accused can be asked to execute bail bonds to appear before the higher court. Option A, yes, as per section 437A of CRPC. Option B, yes, as per section 439 of CRPC. Option C, yes, as per section 436 of CRPC. And option D, no such provision. So what should be the correct answer? What should be the correct answer for this particular question? Question number 103. Yes. Question number 103. Its correct answer is A for Ahmedabad. That is, as per section 437A of CRPC, a particular person can be asked to execute bail or bond to appear before High Court. Right? Question number 104. The protection against double jeopardy is contained under which section of CRPC? The protection against double jeopardy is contained under which section of CRPC? Your options are section 302, option section 303, option C section 308, and option D section 304. What should be the correct answer? The provisions for double jeopardy are contained under which section of CRPC? 302, 300, 308, 304. 302, 300, 308, 304. What should be the correct answer? The protection against double jeopardy. So it is provided under your section 300, right? Yes, so it's B is the correct answer. Next question. Question number 105. Under which section of Criminal Procedure Code an accused person can himself be a competent witness? So when an accused person can himself be a competent witness? Section 312, section 313, section 314, and section 315. I have stated this particular question's answer when I was discussing some of the previous questions as well. So if you would have heard that thing a bit carefully, you will be able to answer. Question number 105. Accused person can be a competent witness for himself, right? Under which provision? 312, 313, 314, 315. Option A, B, C, D. What should be the correct answer with 105? Yes. Just let me know quickly. Its correct answer is D for Delhi. That is section 315. Section 315 is the correct answer, right? Is it clear? No. Yes, Vinny ji, D is the correct answer. Question number 106. Now, from this particular question, we are moving on. Your Negotiable Instrument Act. Nothing in section 318 of, nothing in section 138 of Negotiable Instrument Act shall apply unless option A, check is presented within 1 month from the date of issuance of check. Option B, check is presented within 3 months from the date of issuance of check. Option C, the check has been presented to bank within a period of 6 months or within a period of its validity, whichever is earlier from the date of issuance. Question number 106. And D, none of these. So what should be the correct answer with this particular question? Now, the correct answer of this question will be option B for Bangalore, right? When a check is presented within, no Viniji, it will not be C. Remember that before 2018 Amendment Act, its correct answer was C. Now, if you will get the updated BR Act after 2018 amendment, it was simply mentioned in that BR Act that the check has to be presented within 3 months from the date of issuance of check. So the check has to be presented to the bank within 3 months from the date of issuance of the check, right? Is it clear? Now, if you will talk about before the 2018 amendment, its correct answer can be C for Calcutta, but as of now, its correct answer will be B. Question number 107. If in a check, amount ordered or paid is written differently in figures and in words. If in a check, amount ordered, Kavita Thapa, yes, okay, Kavita ji. So, if in a check, amount ordered to paid is written differently in figures and in words. So, option A, the check will be void. Option B, the amount written in words shall be undertaken or ordered to be paid. Option C, it will be presumed that it was altered. And option D, none of these. Yes, Biniji, question number 107B is the correct answer, that the amount written in the word shall be taken into consideration, or according to that the payment has to be made. Yes, Kavita Thapaji, you are also correct. Its correct answer will be B. Question number 108. Which is not a negotiable instrument? Which is not a negotiable instrument? Option A, bond. Option B, promissory note. Option C, bills of exchange. And option D, check. Which of the following is not a negotiable instrument? Option A, bond. Option B, promissory note. Option C, bills of exchange. And option D, check. Question number 108. What should be the correct answer? Yes. Its correct answer is A, that is bond. Yes, Kavita ji, you are correct. Vinny ji, you are also correct. Question number 109. Proceeding under section 138 of Negotiable Instrument Act 1881, which defense shall not be allowed? Under section 138, which of the following defense shall not be allowed? Your options are: option A, the check is not signed by the drawer. Option B, complainant is not holder or holder in due course. Option C, drawer has no reason to believe when he issued the check it may be dishonored. And option D, he had issued the check in discharge of his legal liability. Okay. Question number 109. Which of the following presumption shall not be allowed under section 138 of Negotiable Instrument Act? Yes, question number 109. What should be the correct answer? Question number 109. What should be the correct answer? The check is not signed by the drawer. The complainant is not holder or holder in due course. Yes, drawer has no reason to believe when he's issued the check it may be dishonored. So its correct answer will be C for Calcutta. That is, when the drawer has issued the check, he has no reason to believe that it may be dishonored. This particular presumption cannot be drawn under section 138. Yes, Kavita Thapaji, C is the correct answer. Question number 110. Under section 23 of Negotiable Instrument Act, a promissory note or bill of exchange dated 31st August 2018 is made payable 3 months after date the instrument is at maturity on the. Question number 110, last question for the day and last question from this particular question paper as well. Now, under section 23 of Negotiable Instrument Act, a promissory note or bill of exchange dated 31st August 2018 is made payable 3 months after date The instrument is at maturity on the option A 30th November 2018, B 31st November 2018, C 1st December 2018, and D 3rd December 2018. What should be the correct answer? Question number 110. Yes, what should be the correct answer of this particular question? Question number 110. Yes, D is the correct answer, Viniji. It is simply stated under section 23 of Negotiable Instrument Act that a check attains its maturity after the final date of the payment on the third day of its final date of payment. The check attains maturity. So the check is the final date for payment will be 31st of December, and then 3 days we have to count from there. So 3rd December will be the final date for maturity, right? Clear hai? Is it clear? Any confusion? Question number 110. चेक जो आपका जो प्रोमिसरी नोट या बिल ऑफ एक्सचेंज है वो पेबल कब होगा? 30th of November को, और 3 दिन में मैच्योर होगा, मतलब कि फाइनल डेट विल बी for its payment, final maturity date will be 3rd December 2018, right? So that is it for the day. See you people in the next class. Next we are going to meet on Monday with 2018 ka question paper. Till now we have discussed 2019 phase 2 question paper. Then we have discussed phase 1 shift 1 question paper. Then we have discussed phase 1 shift 2 question paper. Now let me know if you people are expecting something else from my end to discuss with you. Let me just know. अगर आप लोग चाहते हैं कि मैं कुछ और आप लोगों के साथ डिस्कस करूं, I'll be more than happy to discuss that particular thing as well. ठीक है? If you people have attended the video till now, ठीक है? Don't forget to like the video and to subscribe the channel. And don't forget to press the bell icon so whenever I am coming online, you will get the notification. And do check it out. MP Civil Judge Prelims crash course link is in the description box, right? So मिलते हैं next class में with some new discussions, with some more discussions. Meanwhile, take care. Bye bye all of you.